Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the founder of the GTA family law firm Feldstein Family Law Group. Both myself and our entire team practice exclusively in the area of family law. We practice in Markham, Mississauga, Oakville, and Vaughan. And today we're going to have special guest Jordan Dolgin, corporate commercial lawyer, joining us. Jordan, welcome to the show.
Thank you for having me. It's a pleasure.
Now, today we're going to talk about the intersection of corporate law and family law. And I should let our viewers know Jordan's been practicing corporate commercial law for over, I guess it's over 30 years now. I should know that since we went to law school together. I want to start with outside the cases of family run businesses, many businesses may be unaware of how family law matters can intersect into corporate matters. Things like the functioning of shareholders, what happens in a separation. So I want to start with that. Let's start with a situation where you have two shareholders or three shareholders. They're not family members. But how does family law, from your vantage point, impact, say, 2, 3, 4, 5 business partners that are not family members with one another?
Well, it's interesting because if the business is started with owners and shareholders, if it's a corporation, there could be unincorporated businesses like partnerships. But for purposes of today, let's just focus on corporations because those are the most popular, Andrew. Often there are no family members as owners of the business, and that's intentional because the shareholders are not related, and they are the owners. They're the ones active in the business. Occasionally, there could be a spouse that's active in the business, and maybe we'll talk about that in a bit. But in a typical situation, spouses are not direct shareholders, and they're not active in the business. And then the question becomes, if spouses are permitted to be introduced into the structure, or if it's possible that they might, how do you deal with that? So it could be that as a result of a marital separation, there could be concerns that a spouse of a shareholder might acquire an interest in their entitlement, although my understanding is that's highly rare. But in that case where a spouse who's not intended to be a shareholder directly or indirectly might, through a court order, as a result of the work that you do in the world of family law, acquire an interest in shares, the shareholders agreement typically would have a mechanism to preclude that by having the affected shareholder who's going through a matrimonial scenario have their shares turned into cash, and then they have the cash to deal with their matrimonial situation. But go ahead.
I want to start with a couple of things there because number one, I want to say you're entirely correct that it's extraordinarily rare for a spouse to acquire the shares in their former spouse's business, because in family law, we deal with an equalization of net family property, which means we add up what each side's net family property is, and the one with more writes a check to the one with less. We're in a jurisdiction of a debtor-creditor relationship, meaning it's a check being written. And if you're not a shareholder in the business and you can't establish a beneficial interest in the business, you're not getting the shares of the business. What you're getting is a payment of money.
Right.
So that's extraordinarily rare.
Right.
Then we get into situations that you say a shareholders agreement could deal with, i.e. if you're separated or there's a court application, you could word things in a shareholders agreement that triggers an event that would lead to one shareholder having to sell their interest. Now, that leads down to some interesting positions because from a family law perspective, we deal with the value of the business.
Right.
And if there's a formula that measures that particular shareholder's value and they actually get paid, that's probably going to carry the day.
Right.
But the flip side of that is, what happens now? I picture if I own a third of a business and I put my life and effort and energy into that business, and I'm 45 years old, and now I'm bought out of that business because of something I signed in a shareholders agreement. How am I going to make a living now? How am I going to earn an income? What was my buyout? So there's a lot of risks that flow with that.
Yeah, this is a discussion we could spend the entire segment on, so I'll try to abbreviate it, Andrew, but I've been in situations where someone was kicked out of a company because a shareholders agreement was very loosely drafted. This was someone who the majority wanted to get rid of. This person went through a separation, and they used the separation provision to get rid of him, even though they didn't want him to resign his employment. This wasn't one of those, you're leaving the business, here's your money, resign as a director, resign as an employee, goodbye. This was, we're going to use your family law scenario to get rid of your shares, but we're going to let you keep your job. It was a horrible scenario.
But the flip side of that is, if you take a company, and I'm just playing with numbers, and
Right.
3 partners, and the pre-corporate tax income is 1.5 million,
Right.
and each partner takes a $200,000 salary.
Right.
Each of those partners may be very happy with that accumulation of wealth that's happening within the company, maybe with a target to an eventual sale.
Right.
And now being bought out is financially devastating, because they're going to be told you're no longer sharing in the profit and you're getting paid your salary each year, or get terminated, because the problem is, as we both know, as you get older, you become less employable because you have an expectation of a high salary employers want to have. So I guess I'm looking at it from the perspective of a family law lawyer that's going to deal with the fight. And I say, well, gee, thanks for giving me the value. But I'm also thinking of now support's being impacted by the income quantification that's going to happen.
Right.
And there's some devastating impacts that can happen by, as you say, putting it into cash at a time when someone may not want it put into cash. I see that as being problematic. The other thing that I think people don't appreciate when you have partners is the moment they get separated, your books and records are now really going to be open for public consumption. So I've had situations where, and you can tell me whether you've had clients call you with complaints about this, where you have a partner owns, say, 15-20% of the business, they're going through a divorce. If I'm acting for their spouse, I'm demanding all sorts of corporate disclosure, and the company gets really upset at giving me that corporate disclosure. And I brought motions against the company and forced the company to give me that corporate disclosure. And I say that because sometimes a company, I'm assuming clients will come to you and you have 100% shareholder, they're 60 years old, they're saying they want to slow down, they want to take on a junior partner, and they want to sell them 10 or 15% of the business, and they may not appreciate that, okay, it's great, I'm selling them this piece of the business. But if they go through a separation, all the books and records are going to be open for their spouse to see.
Yeah, I mean, these are, of all the issues they get, and a lot of them are challenging issues that need to be negotiated in a shareholders agreement. The family law issues that you raise are so far down the list of what people think is probable that there's no discussion, and certainly family lawyers aren't consulted. And if there are any discussions, they're at a very superficial level, because you're dealing with a corporate lawyer like me that has limited knowledge of family law. And just one thing that's interesting also is that these clauses that can provide for a potential buyout on separation, I've seen 2 very different variations of those clauses. The one that I like, because it's the suitable one, is that the potential buyout is only triggered if there's a final determination by a judge awarding an interest in the shares to a spouse. Like the very end of the process, if that's the outcome, then the buyout deals with the reality that now we have a problem because we have an order, and it's not hypothetical, it's real. But I've seen those clauses drafted so that the trigger for the buyout is not at the end of the process with the judge's order, but at the very beginning. It's the mere separation which might lead to an interest of a spouse, which triggers the buyout, which in my view is highly premature, because as you know, so many things can happen along the way. You don't know what the values are, you don't know what the process is. So it's interesting how corporate lawyers draft these buyouts really differently.
Well, I don't necessarily think they've given much thought to the family law issues, but it really, what it does jump out to me and turns my mind to is I think if I'm giving the scenario of five partners that are all at arm's length,
Right,
your suggestion for a clause is the perfect clause. It makes sense.
right,
When order happens, that triggers the event. The likelihood of it is remote. People
right,
get to carry on business. But I'm going to circle back to a different one.
right,
And I'm going to take the one where, let's say in my law firm, I have two children. Both of my children join me in my practice, and I give them a certain percentage in the business. And I say to them, I want to sign a shareholders agreement with you.
right,
I may really like that provision
right,
because if I put the provision that you said you don't like in, and
right,
one of them splits up with their spouse, I
right,
can invoke that provision for an immediate buyout,
right,
which may even include what their terms of employment is because they may already have an employment contract for their compensation.
right,
Now, by buying them out with a methodology or a formula that exists in the agreement,
right,
I'm taking away a lot of the ability for
right,
the spouse to come after me because I can say, well, I exercised the shotgun and the agreement, for lack of better words, that allows me to buy
right,
my child out. I bought my child out at the prescribed formula.
right,
And now you don't get any disclosure on income because all my child is an employee and
right.
they have the same employment contract that every other employee in my firm has.
So if I understand you correctly, if the triggering event for the buyout is the separation and not a court order relating to it, if it's the separation and within a week of getting notice of separation, you exercise your buyout and you turn shares into cash, okay? Now you don't have to deal with the spouse's lawyer's request for corporate disclosure because the
I
there's no
think that
there's no shareholder, there's no relationship, there's
I
cash
think the disclosure is going to
over.
be, I think the disclosure is going to be limited to the formula within the agreement. And I think
Right,
there's obviously going to be questions that if that shareholder agreement is signed a year before the separation or 2 years, there might be a bad smell to it. Like,
right,
we went and got it done at the same time the couple started marriage counseling. There may be
right,
a
right,
cloud of
right,
odor that's going to open the
right,
door.
right,
But if I said to my child, you're joining the firm, here's the shareholders agreement you need to sign as a condition of acquisition of your shares, and
right,
then 10 years later they get separated,
right.
that may be something challenging for somebody to attack.
Well, because it's 10 years and arguably it was bona fide because it was done well in anticipation of the ability to play games, if you will.
Exactly.
Right.
So it may be a really elegant way to
Yeah.
get around some of the problems that exist. And I'm not going to say anything is foolproof because it's not
Right.
until you appear in front of a judge.
Right.
And if I had my two children as partners and I had a non-child as a partner, and the
Right.
partnership or the shareholders agreement had a different clause for the non-child, well, now I may be opening the door, right?
Right. Right. Right.
So there's certain thoughts that you have to think about and explain why, but it just becomes an interesting scenario that gives
Right.
you another way to try and block the
Right.
disclosure that's going to be coming.
Right.
And to me, those are some really complex and interesting issues. And I think one of the problems is if you go to your clients and you say when they're doing a shareholders agreement and you're talking about certain provisions or disclosure or taking somebody on as a partner,
Right.
I suspect 9.9 times out of 10, if you even
Right.
raise that with your client, they're going to say, we're not interested. We don't want to spend the money on somebody like
Agreed.
this. It's too remote.
And just to close the loop on your initial question, so that's a scenario that a shareholders agreement would deal with to address or to circumvent having a spouse becoming a partner of the business or an owner of the business. Another is when you've got holding corporations. So Andrew becomes a shareholder of a company, and for tax reasons, he acquires his shares through a corporation. And the rules in the shareholders agreement are, Andrew, you can include your spouse and family members in the ownership of your holdco or tax planning, but you have to control the holdco. If you set up your holdco where you only have 40% of the votes and your spouse has 60% of the votes, you're now offside the shareholders agreement. It's your wife that has control over your shares because she has, or he has control of the holdco. And that was not part of people's reasonable expectations. So you want to be mindful of ownership of holdcos in corporations too.
But then when you get to the holdco, so let's say I'm not a law firm, so there's no restrictions on what my spouse can own. And I have 51% for control. My spouse has 49%.
Right.
Doesn't stop my spouse from getting all the documentary disclosure about the business.
Right.
And if I'm doing something to somehow negatively affect my spouse's interest in the business, their options and their ability to attack it are far greater because there's all the remedies under the OBCA for oppression are now available to my spouse.
Right.
And it becomes a little more interesting. And the problem is sometimes people don't always sign the shareholders agreements, and there may have been an agreement that we're going to each be 51-49, and you treat each other as 50-50, even though it was 51-49. And then all of a sudden, what you thought was a well-laid plan, the gray starts to come in. And who really is the controlling?
Well, this is where there's always conflicting objectives. Clearly, when you've got a successful company with multiple shareholders and they all want to do their personal tax planning, and they introduce holding companies and family trusts for the purpose of sharing income and capital with family members to reduce taxes, and all the shareholders are doing it, they're all trying to obtain lawful tax benefits. Okay. They never intend those family members to have a legal interest in the business, but if there's ever a dispute, they forget that those family members, whether it's a trust, a holdco, whatever, will have rights as dependents, rights as beneficiaries. Yeah.
One of the problems we get into is family-run companies where the husband and wife are both involved. Now, whether it's in the opco, holdco, one of the problems that we create is what is a domestic contract in the Family Law Act? And a domestic contract is an agreement that deals with two spouses and the financial ramifications of that relationship between the two spouses. So I haven't read a case that does it, but my feeling is that a shareholders agreement is also a domestic contract. And why I say that, it entails certain triggering events. So when you're doing up a shareholders agreement, or a corporate lawyer is doing up a shareholders agreement, and two spouses are parties to it, I think of that as a domestic contract. Now, they each will probably have independent legal advice, but I expect it's corporate commercial lawyers who've given independent legal advice. One of the other hallmarks of a domestic contract is financial disclosure between the two spouses. And I suspect that that is never done when there's a shareholders agreement, because I don't see you giving a 13-1 financial statement to your client who's a husband and the other corporate lawyer giving it to the wife and saying, go complete a 13.1 financial statement, which lists your assets, liabilities, and your expenses at date of marriage and date of marriage and current. I don't think any corporate lawyer does that.
No.
The moment you're not doing that, you're now taking the risk of letting a law lawyer like myself in a family court upon the breakup take a run at the shareholders agreement and saying it should be set aside because of lack of financial disclosure. And somebody may say, well, what's the relevance of that for corporate governance? And I would say, well, if one spouse has $5 million and the other one has $200,000 and somebody wants to trigger a shotgun, well, that really is relevant, because that goes to the power dynamic that you should have disclosed as spouses that you wouldn't disclose in a corporate context. That then leads into everything else. So there's a lot of layers to what you're creating. And the moment two spouses are signing a shareholders agreement, I think there's the layer that now gets added to it of it being a domestic contract. And
it's interesting because there are scenarios where one spouse starts a business and it could just be a passive corporation owning real estate, or it could be an operating business, but really only one spouse is active in the business. The other is made a shareholder for tax planning only. But there are cases, and you've had many of them, where both spouses are critical to the business. They both started the business. They're on the board. They have signing authority, and they have equal ownership, more or less. I mean, to me, that's really different. In the first scenario where you've got a spouse that is an owner in name only for tax planning, who is not really interested in the business, contributing, etc. You know, if there's a marital breakdown, the spouse that's operating the business wants to be in a position while they're dealing with the matrimonial issues to protect the business, possibly eliminate the other spouse's ownership, take them off the board, remove them from signing authorities, you know, create that dividing line. Whereas when they're both bona fide shareholders, a lot of those issues aren't relevant.
So there's two ways to look at it. And I've had this discussion with many clients over the years. In the first scenario where the spouse isn't involved in the business, they come in and they say to me, I'm a partner in the business. Well, they are a partner in the business. It means until they're bought out, they get to share in the appreciation. After they're bought out, that spouse is going to have a higher income because they're no longer splitting, meaning more to pay spousal support and child support with. But I also say to them when they start beating their chest about the business, say, wait a second. Do you know how to run this business?
Right.
If you wanted to buy out your spouse, could you walk into their office and run the business?
Right.
And I've had them think about it, and usually they say, I wouldn't have a clue. So I say, okay, now we got to play ball with where either the business gets sold or he or she buys you out, because there's a practical reality that enters into it, which is you just don't have the skill set, but you don't want to be treated improperly as a partner until you're bought out.
Right.
The second scenario, when they're active partners and they're both in the business and they both play a relevant role, that's a different formula, because the discussion is, can the two of you continue in the business and function in the business together? Because, you know, it's one thing to have a business relationship where I'm sitting at my desk and I'm doing work, and if you were my business partner and you're in the office next door, great. But then what happens when all of a sudden my spouse is going for lunch with their new boyfriend?
Right.
Or I'm going for lunch with my new girlfriend.
Right. Yeah.
Those are practical problems that you have to say to people. If you're going to go into business with your former spouse and you're going to work in the same place with two offices there, you have to think about how you're going to be able to accept that. Because if you can't accept it, there's a negative dynamic. And sometimes the question is, who really is needed in the business? Because sometimes one person is operations and the other person is the sales and has all the client relationships. So sometimes one will still buy the other out because they have a better skill set to keep the business going. And other times they will stay in the business. And interestingly enough, much to the question I said to you about shareholders agreements before, in those scenarios, we'd actually do a separation agreement and have corporate commercial lawyers doing a concurrent shareholders agreement.
Right.
So that the separation's dealt with and the corporate governance of how they're going to govern themselves going forward is being dealt with concurrently. And nobody can challenge the shareholders agreement for lack of disclosure because it's happening as part of the
I agree with you. When spouses are partners in a business with no shareholders agreement and the marriage ends and it's determined as part of the settlement that they're going to remain business partners, I think you need to negotiate as part of your matrimonial settlement a brand new shareholders agreement as if it was a startup between arm's length parties. 100%.
That's how we do it. And in fact, you have to realize there's a higher probability that this isn't going to work.
Right.
For the reasons I said, you know, all of a sudden they're having a fight.
Right.
You know, they have a fight about what happened with the kids at a function.
Right.
And now that flows into a business transaction, because I'm not going to be fighting with my partner about my kid's graduation party, my kid's wedding, my kid's whatever.
Right.
I'm not going to feel slighted about that stuff. It's not part of the mix and the dynamic that may happen here. So you really need to be, I've said to people before when they've done this, you really need to think about the exit strategy of what happens if the two of you can't get along, and you have to realize about the power imbalance of that and how you're functioning, because a shotgun may not be a fair remedy. It may be, let's sell the whole thing.
But it's tricky because I'll have a client, usually through their accountant, that will give me instructions for a new business, create this company, and the spouse should get, 49% voting common shares. And we have the discussion, and I say, is the spouse going to be involved in the business? And the answer is no. And I'm saying, if there's a marital breakdown, you want to be in a position, you still have to respect your family law obligations, but if you're the one running the business, you want to at least give some thought to how do I, efficiently and quickly and unilaterally eliminate the spouse who's not involved in the business as a shareholder, director, officer, signing authority.
And all of that isn't easy. And then they're going to be questioning every check that you write from the business if they're a partner, which is another problem.
But then I'll say the accountant, like, maybe the spouse should have, shares that have no votes and no equity just for dividends and income splitting, so that those shares can be quickly eliminated for $100. And the accountant would say, I want the spouse to have valuable shares to get a second capital gains exemption.
But it's a problem from a family law perspective. And I would tell you, you have to pick your poison. Do you want to protect yourself from your spouse or protect yourself from the tax person? It really is one or the other. And just a simple illustration, I've said to my viewers many times, I'm separated, I'm divorced, it's over 10 years now, but a lot of people would have put the real estate that I own through my business into my spouse's name for creditor proofing purposes. And I thank God I didn't do that. And I looked at it as a family law lawyer. So would I have liked to have been my former spouse's tenant?
Where
she could have said, I'm the landlord, you're only renting so much space, I'm taking an office in your building and I'm going to sit next to you every day and hear what you do. I would have despised that. And that could take me a year or 2 or 3 years to get her out of there by the time I buy her out. That's part of the nuance that people don't appreciate and say, oh, well, it's family law, she's entitled to half. Well, she is, but also only half to the date of separation. So if I'm putting that real estate if you think about the industrial buildings over the past 5 years in Ontario, they've shot up like crazy in value, right? So if my spouse jointly owned my industrial building because I operate a factory there, and the price of that property has gone up $5-6 million post separation, for each of we own it, she shared in the ride with me. If I solely owned it, that ride is all mine. And until I sell it, I don't necessarily have any income, certainly for child support, and spouse support's a different issue. But my point is, there are different ways for me to handle it. And I'm losing out on a lot of flexibility of what I can do by virtue of me making her a shareholder. And that to me
is that's the challenge, because a lot of our clients, they'll want to take steps to deal with their creditors. They're going to want to take steps to reduce their taxes, and they're also going to want to take steps to protect themselves against their spouse. Those are 3 different competing objectives. And often you can set up your affairs where you can achieve 2 of those 3, but you can't get all 3 because you have to trust somebody. Unless we have property ownership rules where you can put title in the name of a pet, which we don't have, but if we did, that would then you'd be able to get all 3.
Or somebody would say there's a litigation guardian for the pet.
Oh, there you go.
So Jordan,
I
know that we're out of time now, but I wanted to say thank you. We hope our viewers have got an idea of how to handle the issues at the intersection of corporate and family law, and what key laws play into the issue, and how corporate lawyers can assist clients in these matters. If you're looking for assistance as part of your separation or divorce, please feel free to contact us at our website, separation.ca. The next Ask Andrew show will be on Tuesday, July 30th, 2024 at 12 noon. And thank you for watching.